SJC-12465, Commonwealth v. Jean, Alexis.
Ms. Mello, good morning.
Good morning. May it please the court. Emily Mello on behalf of the Commonwealth. The trial prosecutor, Susan Dolan, is here with me today in the audience. This is the Commonwealth's interlocutory appeal of a motion to suppress, raising what is a novel issue before this court, whether under Article 14, as under the Fourth Amendment, warrantless entry and arrest due to exigency is proper when the police have not yet secured a warrant, but they go and an exigency is created from the defendant's actions in response to lawful police presence.
Do we have to reach the Kentucky versus King question, given that there was never a knock on the door?
I think that in the circumstances of this particular case, it can be distinguished from Kentucky v. King and even some of the Massachusetts cases like Molina and Ford, in the fact that here the police did not reach the door. But I think that regardless, it comes down to a matter of kind of how far do you go? What can they do? Can they surround the house? Can they walk up to the front? I think that you have to look at those cases like McAfee and say what the police are doing here is proper and is legal, and they're taking lawful action by walking up to the front and potentially knocking on the door, and that is not a violation of the defendant's rights. And should he decide, like they said in King, to not stand on his own constitutional rights, then that is the fault of the defendant and not the fault of the police.
What do you mean by that, not stand on his own constitutional rights?
So, because the defendant could not answer the door, he could stay inside his house, he could answer the door and say, I don't want to talk to the police. There are a lot of circumstances where the police, and then at that point, the police would have been forced to get a warrant. And you'll notice—
But why isn't not answering and turning to run a part of your constitutional rights? Is there not a constitutional right to run away from somebody you see coming? And I mean, they were in plain clothes, correct?
Yes, but they did have their badges displayed. And one of the police officers was familiar with the defendant, so he did recognize him.
I guess the bigger question is, why should we change our law?
So this is why. I'm going to start with Commonwealth v. Ford.
Because, I mean, just
Yes.
to preface it, in this case, the police knew what they were doing. The detective, for whatever reason, filled out the warrant request, the arrest warrant request, put it in the court box and kind of waited, and then called the next morning to the warrant apprehension team. But if he had done what he would set out to do, you would have had the warrant. The police know the rules. They would have had an arrest warrant, and we wouldn't be here. So why should we change our law?
So I'm going to answer that in two parts, if I may. I want to note first that, well, a warrant could have been obtained, an after-hours warrant, by Detective Poley. Sergeant Kenny, in the morning, when he received the information, believed that the identification was fresh and had just been made, either that morning or overnight. So there was a miscommunication there. Detective Poley couldn't remember why he didn't get that warrant, but as far as Sergeant Kenny and his actions, he believed—
Couldn't he have gotten a warrant that morning?
I'm sorry?
Couldn't he have gotten a warrant that morning?
Before the court opened in the morning, at that point it was 7 in the morning, probably not.
Did he give any thought to a warrant at any point?
I'm sorry?
Did anyone give any thought to a warrant? Doesn't seem like
He
anyone—
knew that there was not a warrant at that point, but he felt that given the situation, given the home invasion, the fact that there was a gun, that a baby had been struck, that another victim had been struck, and the fact that he knew that that defendant had been at that rooming house a week before, where he went, and the defendant was cooperative at that point.
Let me ask you about that exigency point that you raised and the danger posed by this defendant. Isn't that argument entirely belied by what the first police officer did? Because to the extent that you argue that there was a danger, a child was struck, there was a gun out there, the actions of the first officer to go home and not see this through kind of bespeaks the fact that he didn't consider this to be an exigency or a dangerous situation, because if it was a dangerous situation, he wouldn't have punched out at 4:30 and just gone home.
So Detective Poley's testimony on that point was that this was the type of case where they would typically seek an after-hours warrant, and he could not recall why he did not.
He testified that we assess these things, and when we assess these things, we look to see the nature of the case, the danger, et cetera. And his actions speaking louder than words, he decided not to get a warrant at that time.
Sure.
So aren't you kind of bound by that decision? And then afterwards, if you argue exigency, it's kind of a tough argument to make given the initial response by the police.
So the exigency isn't created until the police are already there, and I want to go back.
I meant the danger posed by the defendant, the public safety risk, which is what you are arguing.
I don't think so. I think it's an objective analysis, and I think that objectively, despite what Detective Poley did, and he did say he didn't recall why he did it, and I'm not saying that excuses his actions, but I think that objectively, looking at the situation, an armed home invasion, where the defendant displays a firearm and does hit a baby, and the owner of, or the family that lives in that apartment, he strikes two people.
Wouldn't it be a different case if the first police officer, and I'm blanking on his name, Foley?
Poley.
If that police officer had looked for the defendant, couldn't find him, and made a good faith effort, and then the next morning called the fugitive people and said, "Look, really, we're looking for this dangerous person," and the fugitive officer said, "Well, I know where he is. He's at the rooming house." That's a different case than a case where a police officer has the ability and the foresight to get a warrant and decides just to put it in the court box and go home for the day, as opposed to calling someone out from the clerk's office.
So I would respectfully disagree with that, and I would get back to the point where you said, why should we change our law? And this is why, because I'm going to start with...
Before you do that, our law is muddled, isn't it? Because Molina's decided before King, right? Molina relies on both Fourth Amendment and Article 14 analysis. And doesn't that mean we've got to clarify whether Article 14 provides a different level of protection than King and the Fourth Amendment? So I don't know if our law is settled, right? It's unsettled,
Yes,
isn't it?
I would agree, and thank you, Justice Gafter. That's actually exactly where I was going to start. I was going to say Commonwealth v. Ford, which was decided in 1975, was based on a Fourth Amendment analysis when they came up and the court chose to use this reasonable foreseeability test. Then Molina, which relied on the Fourth Amendment and Article 14, relied heavily on Ford in making its decision. Ford, which was decided based on a misapprehension of the Fourth Amendment. Then, when Kentucky v. King comes out from the U.S. Supreme Court, they rejected that reasonable foreseeability test under the Fourth Amendment. So that abrogates Commonwealth v. Ford and means that not only is Commonwealth v. Ford incorrect, but Molina, which relied on Ford, is also incorrect. And let me just explain to the court why that reasonable foreseeability test, and this goes back to the point of, I think it was Justice Gaziano that was asking, would it be a different case if the factors leading up to the exigency had been different? And I think that the answer is no. King rejected a reasonable foreseeability test, and with good reason, because it would create an unacceptable degree of unpredictability. The court would have to look in hindsight at not only what the officers knew and what they were thinking, but also what the defendant knew and what was the defendant's state of mind. Would he create an exigency under that circumstance?
Counsel, that's where I guess when I read that, I really didn't understand how they came to that conclusion, because we always do that, don't we? We always look at everything in hindsight, and there's always a lot of unpredictability because facts change in cases. And it's really not what in the defendant's mind, but we'd be wondering what the police thought was in the defendant's mind. Isn't that the distinction?
But I don't think, even though we do have other tests where we look at like reasonable suspicion, that has reasonable in it, but we're looking at specific and articulable facts that are known to the police objectively. Here we're asking the police to almost guess as to whether a defendant will, like I said, stand on his own constitutional rights or not.
What about Justice Ginsburg's concerns in her dissent about the warrant requirement? That were we to do this, is this a go-around where the police could not do what they set out to do in this case and apply for an arrest warrant, and basically, and I know this is Jardine's argument, but basically knock and announce and say, hey, you home? And kind of shake the hornet's nest?
So I would say absolutely not. I don't think that any police officer would say, I'm going to go to this house and create exigent circumstances and put myself in danger in order to avoid getting a warrant. I just don't see that as...
No, they're going to go and watch the person run. I mean, the police, in this case, said that they went to the rooming house because, A, they wanted to get information, and B, if he was there, he's going to get arrested. That was their intent.
I believe that, well, first, they didn't know if he would be there because they weren't sure if he was
Right,
still
it's a
living
rooming
there.
house, but they did think they had seen him there the week before, and I think the testimony was, the police officer candidly said, if we saw him, he was being arrested.
Yes, he did say that. But they weren't going there, and like they say in Molina, with the deliberate intent of creating exigent circumstances. That's not something that I believe, and I hope that this court doesn't believe, that the police do. When your exigent circumstances happen, that is always a concern and a safety concern for the police and for everyone, and that's why we have that exception to the warrant requirement. The police were going there, and they thought, maybe we can get some intelligence, maybe he'll be there. We went there a week before, and he spoke with us cooperatively. Maybe he would have been cooperative. Maybe he would have spoken with them. Maybe he would have not answered the door. Maybe he would have not been there. The police don't know at that point, and I don't think that we can ask them to predict that. And if we were to ask them to predict that, we'd be creating a paradox where the very same actions in one instance would require suppression, and in another instance would not.
Well, I guess I don't understand why that's a problem. I mean, we do that all the time with all sorts of things.
So I'm going to give you a hypothetical, which I hope will illustrate what I'm trying to say. Say there's been a homicide, and the defendant is not yet charged, he's a male, but they have probable cause to charge him. They also have probable cause to charge his girlfriend as an accessory after the fact. They're trying to build their case. They want to go to the girlfriend's apartment and talk to her. They don't get a warrant because they're not sure they're going to charge her, but they definitely have probable cause. They get to the apartment, they knock on the door to try and talk to her, and exigent circumstances are created one way or another. They have to go in and they find the murder weapon. Now that gets suppressed because they had enough to get a warrant and went to the house to talk to her.
Let me ask you, if Sergeant Kenny had called you that morning and said, here's the circumstances, do you tell him to do what he did?
I think if Sergeant Kenny had called me that morning, I would have said, your best bet is to get a warrant.
Right. So I mean, isn't it fair to say that what he did under all these circumstances was not reasonable to do?
Oh, I think it was certainly reasonable to do. The fact that a police officer would call me and I as an assistant district attorney would say, I think you should get a warrant, doesn't mean that other paths are not reasonable.
Was it reasonable? Is this anything you would say if you were teaching police officers what to do? Would this be within the realm of what you would say would be a reasonable course of action for a police officer to take under these circumstances?
I think this is a reasonable course of action for a police officer.
And isn't it compounded by, other than that they had actually applied for a warrant the day before?
And so that's,
It was sitting in the court box.
and that's exactly the point. And that's the point that they make in Kentucky v. King, and the point that I would encourage this court to look at, that there's always going to be different circumstances, but we need to look at the objective actions of the police officers. Objectively, they get to the house and they walk up the front door to knock on the door. They are not violating his rights. They are not threatening to violate his rights at that point. If he chooses not to stand on his own constitutional rights, the police should not be punished for that.
But the Supreme Court focused on whether it was lawful, okay? Why should we not focus, since we've said many, many times that the touchstone is reasonableness? Why should we not focus on whether or not what the police did was reasonable?
What the police did was reasonable. Whether there was a better...
But you're starting with the point of when they went to the house, that they made the decision to go to the house the next morning. That's when you're starting to the analysis. You don't want to take into account whether or not the police acted reasonably in not getting a warrant.
Well, the reason I would encourage the court to start the analysis there would be because the information, to look at the information of the people that went to the house.
Why? Isn't police knowledge inclusive of what happened the night before?
Certainly, but the police are not required to get a warrant just because they have probable cause. And even though it may have been the best course of action, that doesn't mean that the defendant's rights were violated.
All right, thank you.
Thank you.
Ms. Carty, good morning.
Good morning. May it please the court. Emily Carty for Mr. Alexis. I will start with Justice Gaziano's question, which is why should we change our law? And we shouldn't.
But I think I read your brief. I find that really perplexing because just the way your sister just presented the case, Ford is a Fourth Amendment case. Molina is a blend. The U.S. Supreme Court has told us in Michigan versus Long that they're going to presume you're relying on the Fourth Amendment when you blend the analysis. So how do you get there that we've made an Article 14 determination?
I think because this court has said that there was an Article 14 determination in Molina.
In Molina, show me in Molina. In Molina, the only reference is sort of a string quotation of the Fourth Amendment and Article 14. And that's exactly what the U.S. Supreme Court has indicated we shouldn't rely on.
My recollection is that, yes, Molina says that under the Fourth Amendment and Article 14, based on the rationale of both of those, then we hold the following, or that we come to the conclusion.
That's what Michigan versus Long. Have you read Michigan versus Long?
You know, I have not.
Okay,
I'm
well,
not
that's kind of the key U.S. Supreme Court case on how you interpret blended analysis, because they will presume that you're relying on the Fourth Amendment because they're instructing us to be clear what provision we're relying on.
I'm not familiar with the case, but what I will say is that we have, since Molina, have applied Article 14 to other cases, the same analysis to other cases.
Which
And so
case have we said we're relying on Article 14?
I mean, I believe that it has other cases that
Which
have
one?
applied Molina. I believe McAfee.
McAfee's an appeals court case, right?
Well,
And the appeals court case, I know well, because it's Gentle where
Right.
we interpret that.
Yes.
And after Gentle, there's a case by Justice Ditkoff where he says he doesn't have to deal with that because there's clearly no created exigency. I get your argument other than this, but I do think we have to clarify whether Article 14 is different than King. But you seem to think we don't need to do that.
I think, well, of course, I mean, we're here, and so this court is probably going to clarify what the position of Massachusetts law is on this. And so I would say that there is no reason to stray from the standard that we have been using. Kentucky versus King simply lowers the floor, and we don't have to lower our own floor to meet it. We can continue to use a standard that is more elevated and more protective than the Fourth Amendment, and I would urge this court to do that, because Justice Ginsburg makes some, I think, excellent points in her dissent, namely that the Kentucky versus King rule allows circumvention of the warrant requirement.
What about the appellant's argument in their hypothetical? There are a multiplicity of reasons why the police have probable cause to arrest, and they decide they want to talk to somebody in a residence, and they have really good strategic reasons why they're not ready to make the arrest.
Right.
And in those circumstances, if something happens and the police enter the dwelling in response to exigent circumstances, everything is suppressed, even though they went there with no intention to arrest?
Well, I think that their intention to arrest is relevant, and we see that in McAfee and Polanco. Those are appeals court decisions, but they are instructive in how Molina has been applied. That, you know, if the officers are going there for a purpose other than to arrest someone, but it is still reasonably foreseeable that their presence may induce that person to flee or induce some sort of exigency, then whatever court that is evaluating that specific circumstances would simply apply the second part of the Molina test, which is, was it reasonable for the officers to delay in getting the warrant? And if they would weigh the investigation versus the delay, and we trial court judges do this all the time. There's no evidence in the record, and I can think of no reason why trial court judges aren't capable of doing this, particularly since they've been doing this for decades.
If they hadn't gone back to the office and started working on the warrant, would that have been reasonable for them to go right to the rooming house? I understand why it may not be reasonable if they go back to the office, they prepare the warrant, they leave it in the box, and they don't do anything. It seems like it's sloppy police work.
Yeah.
But I'm wondering, could they have gone to the house right up front? Was that an exigency right then and there?
No, Your Honor. There was no exigency before the officers stepped foot on Mr. Alexis's home, or in the area of Mr. Alexis's home. The exigency didn't occur until they arrived, and there's no evidence on this record of any specific information about a flight risk. The crime of violence alone, that would be sort of the one factor that would maybe inure to the Commonwealth's benefit, but that alone cannot create an exigency sufficient to enter someone's home without a warrant. And you know, gets back to first principles here, that the presumption is that we don't get to enter people's homes. The officers do not get to enter a person's home unless they have a warrant. It is sort of the most sacred, for lack of a better word, piece of our search and seizure law and our right to privacy. And so the exigency this is an exception. The officer's ability to go into his house is an exception.
Can I ask you a what if? Let's assume that the morning arrives, Sergeant Kenny says, well, I would have preferred that they had gone at night to obtain a warrant, but they didn't, so I've got to play the cards I'm dealt. I'm going to arrange to get a warrant. It's going to take some time, so I'm going to send a group of police officers to do surveillance around the house. Ideally a discreet surveillance to see whether or not he leaves, with directions that if you see him walk out of that house, you arrest him. A reasonable course of action for the police to take?
Absolutely.
Okay. And what if during the course of that surveillance, Alexis spots the police? Does that arguably create the exigency now that would permit them to enter based on the concerns that caused them to enter here?
I don't think simply recognizing that the police are around the home is an exigency. I don't think that, I mean, again, there's no, if he flees, they are there and can arrest him if he is outside of his home. And I don't see any of the other sort of factors that would allow them to just enter. I think the whole point of having a secured perimeter is to enable the officers to sort of give themselves enough time to then go comport with our constitutional principles and get a warrant.
Okay, but you agree that it's not merely that the police could trigger it, but if the police trigger it by pursuing a reasonable course of action, we arguably have a different analysis.
Yes, I think that's right. If they trigger it and if it's a discrete perimeter, for example, and they didn't, it wasn't reasonably foreseeable that perimeter would have created an exigency, then it's a different calculus and it's a different case.
Counsel, can you address the difference between impracticable and impractical as it applies in this case?
I have not considered that
All right,
question.
but
I will
what we've
try.
held is that impracticable refers to something that's not possible.
Right.
And that's the rule for exigent circumstances in the absence of a warrant. It has to be not possible.
Right.
So how does that, and whereas impractical is something that's just hard to do. So one's not possible, one's just hard to do. We're dealing with the not possible, in the not possible realm. So how does that play into your facts?
Well, it certainly was, on these facts, extremely possible and for the officers to have obtained a warrant in this case. I mean, they could have filed the application for the warrant, obtained the warrant, and probably arrested Mr. Alexis before Officer Pooley, needed to get home for dinner. I mean, the after-hours warrant, it was well within his discretion to get an after-hours warrant. The judge makes those findings, and those findings are well supported by the testimony. And they didn't. And so that fact completely belies any claim that there was a real exigency. And so, I mean, here, yes, it was very, very practical and very, very possible for the officers to get a warrant. And I mean, in other cases, you see even in the appeals court, I believe it's McAfee, there was a time range of about 3 hours. And the court there says, you should have gone and gotten a warrant. Because it's not just that they're giving up the case or they're giving up their investigation while they're going and getting a warrant. One, there's no evidence that that Mr. Alexis or knew that the officers had sort of an idea that he was a suspect, right? And so that's an important consideration.
Even though the victim recognizes him as a high school classmate,
Right.
there isn't the possibility that the defendant also said, whoops, I just robbed my high school classmate.
I mean, there may be, but there's nothing in the record to support that. It's just that the victim recognizes someone.
Isn't it a reasonable inference?
No, I don't think so. No? I think that it's very possible that someone from high school could recognize you and you not know them if you've ever been to a high school reunion, for example.
I don't think we can take judicial
how old
notice of
you are.
that.
Right.
Let
Quite the reunion.
let us assume, for the sake of argument, that we declare the search to be illegal, and therefore the result would be that we would strike from the affidavit in support of the search warrant anything that was the fruit of that entry, correct?
That's right.
There still is the observation of the victim that the defendant did it and that the defendant had a silver gun. And they had separate information to say that the defendant lived there. Would that not be enough to save the warrant? Search for the silver gun.
To save the eventual warrant. Is that enough for probable cause? Is that's your question?
Right, the question is if we strike all the observations, I think we still have in the affidavit for the warrant the fact that the victim identified the defendant,
Right.
that the defendant lived there,
Right.
and that the victim saw the defendant holding a silver gun.
I'm not trying to dodge, but, I mean, this is a good example of where a neutral arbiter is useful and should be the person to make the determination of whether there's probable cause or not.
But there was a neutral arbiter, that is the,
That's right.
and we would have to be that neutral arbiter after
Yes.
having struck. So I think we can say we're neutral.
Yes, Your Honor. That he had a silver gun, and then I mean, yes, I think there's probably probable cause.
Which means you win, but you lose.
Yes, Your Honor. Unfortunately, now that I'm standing here thinking of it, I wish, as I'm standing here, I could think of a way that would not be probable cause, having an identification and the gun. But at this moment, as I stand here, I can't think of a
Now,
reason.
the judge in a footnote said there's no nexus, would not be nexus, although he referred to drug cases. So you may want to ask for a 16L letter.
I appreciate that, Your Honor.
Can I ask, going back to the distinction between the Article 14 and the Fourth Amendment?
Yes.
Doesn't there have to be a special circumstance under which we would say that Article 14 is more protective than the Fourth Amendment? And I'd ask you what the compelling reason would be for us to depart from the Fourth Amendment.
I think, I mean, it's just within this court's discretion. But historically, when you look at instances where this court has afforded Article 14 being more protective than the Fourth Amendment, you've cited some compelling reason. And I think the compelling reason here is to allow our protections of the home to live. That the Fourth Kentucky versus King, the rule in Kentucky versus King, really does damage to the protections afforded to people and in their homes. And that seems to be the crux of Article 14 and protections that we have enjoyed for hundreds of years. And if officers can go up to a home when they have probable cause, but when they had ample time to go get a warrant, which is what we require, and instead just knock on someone's door, hoping that they can hear some sounds or see something that allow them to go in, then why get a warrant?
But does it matter here that they never got to the point of knocking on the door?
I don't think so, Your Honor, because there is evidence in the record that they saw Mr. Alexis and Mr. Alexis saw them. And so their presence is what induced him and induced the exigency. So I don't think that the distinction lies on whether they knocked or not. It's whether their presence there induced the exigency. I see that my time is up.
All right,
Thank you.